do is I can just hold it like this to like live stream it. So that's it. Hi, Roberta.
Hello.
How you doing?
Oh, pretty good. Looks like it doesn't allow me to choose a background, so you're going to get boring green.
I'm sure we'll survive.
Looks like it has me as unknown user.
Yeah, hang on one second. I'm going to slip over to Zoom and let Margaret know, get her address so I can put her into Teams. 1 second.
Okay.
Let me see if I can get over there.
Is that Margaret Cardoza?
Yeah.
I probably got her email address.
Let me just I have her email address, but let me just let her know so she knows. Because I wasn't sure who was going to join today. And I'm going to try to live stream via my phone on YouTube, but it's just like, it'd be easier if they just get this
Don't you
issue
just love
fixed.
technology?
No, I don't. So if I get put off for a second, I'll be back on in a minute. Let's see what happens. It'll connect me over too. Okay.
Hi, Jim.
Good afternoon.
Okay. Hold on 1 second. Margaret, we are having technical issues with Zoom. So I'm going to send you the meeting. We're using Teams meeting today. So I'm going to send that to you. So you'll just click on the link and follow it through. I'm sorry. Hold on 1 second. I cannot hear you. Hi. So what I'm going to do is I'm going to send you Microsoft Teams because we're having technical issues with Zoom. Oh, that's okay. I'm just telling you we're starting on Teams today. So I'm going to jump off here and via email I'm going to send it to you. Okay? All right, I'm sending it. All right, thanks, Margaret. All right. Okay, and go here to people. Let me go to Margaret. Okay, let me get her email. Here. Okay, but I still want to send the invite. Okay, I'm going to share invite. Okay. No. Okay, copy meeting link. Here. Okay. All right, so I think she should be able to join. I sent her the link. Keep an eye on the other one. Not allowed. Session out. Okay, I sent her the link, so hopefully she gets that and she's able to log on. So,
All right, for the benefit of those of us who are on, good afternoon, everyone. Thanks for joining. And it's like half the commission meeting today, but that's a good thing. We'll be able to have a good discussion, I hope. Just in terms of, this is group 3, we're looking at terms. Back last year, there was legislation that had asked us to look at the use of several terms in Maine statutes: private way, public way, private road, and public easement. and to determine whether changes to the current law would improve the understanding and use of these terms throughout Maine statutes. We did look at those, and we were able to come up with draft legislation with regard to private way, which the legislature partially enacted. And so it was a success, but not complete. And so it feels like we didn't finish that assignment. We got another assignment this year to look at 4 specific questions. That was in chapter 642. And I think we've done that in draft form through our subcommittees. And now it's going to be a question of the groups 1 and 2 and the commission wrapping that up and getting that into a report form. So I see my homework and Heather's as well as getting that report together and show what we've done on questions 1 through 4 for this year. But looking back, since we now have a little bit of time at what we hadn't completed last year, it is looking at those terms. And so in our when we concluded group 2, we said, well, let's get together and start talking about terms now that we have a little bit of time and see if there's something we can get going for the end of the year. And so Roberta was kind enough to put something together for us to react to take the lead on this, and has put together a handout. And Heather, did that get to everybody who's on this?
I believe
meeting?
so. I sent it out via email. Everybody should have it.
Okay. And so
if not, I can try sharing.
Great. So Roberta has taken a look at each of the 2 terms, private way and public easement, to get us started, has offered a synopsis of the issues, some suggested changes, and then a recommended definition. So I think what might be most useful would be, Roberta, if you could briefly, walk us through, first of all, what are the problems that you see with private way and public easement? Let's take them one at a time. With private way, what problems do you propose to resolve, and how are those addressed in your proposed language? Does that make sense?
Yeah, sorry, I'm sort of trying to multitask here at the same time because I was trying to see if I could get a message through to Margaret in case the other one isn't working for her. But hopefully she'll get on in a minute.
Okay.
What I did was I thought that if we could do a kind of a dictionary definition where instead of just having one definition of a term, it has several definitions and, numbered 1, 2, 3, whatever, that might be better, because I'm afraid if we come up with new terms, it's just going to make things more confusing, because you already have to think, well, let's see, am I before 1965 or after 1965? Am I before 1976 or after 1976? Because depending on what the date is, I'm going to use different terminology and it's going to mean something different. So if we just add more terms, then we're going to have another date that everything changes. On the other hand, if we go back and try to change what things meant before, so they all mean the same thing, that also gets us into trouble, because it means that we're imposing new conditions on something that didn't exist back when it was first put in. So I thought it was going to be fairly straightforward, and then I thought, well, I have to explain why I'm doing what I'm doing. And I end up doing quite a history of how the terms have changed. The 2 that I think are the most problematic are private ways and public easements. Private roads, I think, are not as much of a problem. Public ways, I don't think are a problem, really. A public way is it's a public road that's publicly used, publicly maintained, open to the public. A private road is kind of the flip side of that it's not open to the public, it's not maintained by the public, except in exceptions. There are always exceptions to everything. So I don't know if you want me to go through all of the history that I wrote out. It's about 10 pages, I think. Or if you want me to just go down what I finally came up with for definitions, and then we can go back and look at the history if people need to see why I did what I did.
Okay, maybe, well, that might make the most sense given the way you laid it out. And that is, let's look at the definition, explain to us what the definition is, just overall. Just go through the 4 subsections you have here. And then we can go back and you can take us through and explain where each section comes from. how you got
Okay.
there.
Um,
Does that make sense?
I'm just feeling a little bit distracted here because I was really hoping Margaret could get on since she had
Who is
been
Margaret?
on Zoom.
Who is Margaret?
Margaret Cardoza, she's, oh, there she is. Good. She made it. Okay. Hi, Margaret. I think she's most interested in the definition of private road. She's on a private road that is both a private road and a public easement. So I think that's why she's interested in being here today. Anyway, I'll bring up my definitions here. As I said, I tried to make it sort of a dictionary style definition with the main definition being divided up into several sort of sub definitions of different things that term can mean. So if you scroll down to page 7 of the handout, where it says proposed definitions down at the bottom of the page, private way. This term may have more than one meaning depending on when and under what statute the way was created. 1, when applied to a road that never was a public way, a private way is a way privately owned and maintained and over which the owner or owners may restrict public use or passage. It's changed a little bit from the definition of private way that's in was it Title 29? Is it? I mentioned it back there. Yeah, Title 29A, Section 101. A couple of things that I added to it was that, if I can find it again here, I keep losing myself. Okay, I added in the owner or owners because in many cases a private road isn't clear that it's just one entity that owns it. Usually it starts off as a person putting in a subdivision, and at the beginning that one person does own it. But then at some point when all the lots in the subdivision have been sold, often the developer just sort of vanishes from the scene and isn't heard from again. And it's a little bit unclear who actually owns it, but all of the abutting lot owners each have an easement over the road. So they would kind of be considered the owners. And I said may restrict public passage rather than just saying may restrict passage, because if it's just one person who owns the whole road and he's the only one using it, yeah, he can restrict passage from anybody. He can say nobody can come on this. This is my road. But when it's a shared road, you don't want one person saying, oh, well, the law says I can restrict passage, and telling the other lot owners that they can't use it. So I said may restrict public use or passage. And then as an example, road signs that say private way, often there's more than one owner, with a number of abutting landowners having shared deed easement and often sharing the cost of maintenance. Then definition number 2, a dead-end road laid out prior to July 29th, 1976 on the petition of an owner of land not yet connected to the public road system. These roads are established primarily for the benefit of the petitioner and allow the public to get to and from that owner's property. Maintenance is the responsibility of the petitioner. So if we go back into the history that I wrote several pages earlier, originally there was kind of an understanding that these were private ways laid out for a private person to get to his private property. And well, yeah, the public can use it too, but it's primarily for that private landowner, so he can get to his place of business, his home or whatever. And so other people can get to his home or place of business. And it wasn't unreasonable to expect him to pay the damages for the taking of the road because it was mainly for his benefit. It also wasn't unreasonable to expect him to take over the maintenance of it because back in the early days, building and maintaining a road meant cutting down the trees and maybe smoothing out some of the rough spots so you could get through with an ox cart or a horse cart. And in some places, roads consisted of a row of blazed trees, and that was all. They just said, here's where you want to go, where the land is passable and you're not going to end up to your neck in a swamp or something. They just blazed out where was a good place to go, but there wasn't really any built road in any sort. But then the understanding of a private way kind of evolved over the years, and they've gone into that quite a bit earlier in this too. That first they said, well, there has to be more than just theoretical public use. There has to be at least some actual public use. The public should be able to use it if they needed to. And then it got to be, well, yes, there has to actually be public using it. And then finally it was, oh yeah, it's open to the public. And then not long after that, they changed the name to public easement to reflect that they are public roads. And that's where a lot of the confusion came in, because that wasn't how they were understood originally. So then definition number 3, a former townway discontinued by vote of the governing body of the town after September 3rd, 1965, but before July 29th, 1976. It was in 1965 that they said that when a road is discontinued, it automatically becomes at the time it said private way. And then in 1976, they changed the term to public easement. So this covers that gap in between when they're so-called private ways. Unless the said vote specified no easement would be retained. After July 29th, 1976, these roads are deemed public easements. Such ways are retained for the purpose of preventing landlocking abutting properties, or for purposes of public access to land or water not otherwise connected to a public way. These often were throughways, although lack of maintenance may result in their no longer being passable for their entire length. The public may provide some maintenance, subject to the provisions of 23 MRS section 3105A, if it is deemed in the best interest of the public for fire and police protection, but it has no obligation to do so and is not liable for defects in the road. Abutting landowners have the right, but not the obligation, to maintain the way so as to preserve access to their property, but receive no compensation for the public's use of the way. And then definition number 4 of private way, a former townway discontinued by vote of the governing body of the town prior to September 3rd, 1965, or a former county way discontinued by vote of the county commissioners prior to July 29th, 1976, if and only if the article or petition being voted on specified that a private way is to be retained. However, there was no statute authorizing such action at either the town or the county level. This is something that hit us kind of hard, because when my husband bought his property, his deed said the road was discontinued. And when he looked up what that meant in the statutes and in the court cases, it said that the road ceased to exist when it was discontinued. And we couldn't find anything in the law anywhere that said that they had the power to keep any kind of easement when they discontinued a road. But then the court decided that they could take an alternative action. Well, we question that, because the powers of the county commissioners were very strictly limited, and they were only supposed to do the things that they were specifically granted the power to do. And retaining a public easement or a discontinued road wasn't on the list. If you go back and read the history, you'll see what the requirements were. After July 29th, 1976, these private ways are deemed public easements. And see, there was something else I was going to say about that. Well, I've forgotten what it was. Anyway, then we go down through my discussion of public easement. And if you scroll on down to the bottom of page 9, proposed definitions. Public easement. This term may have more than one meaning depending on when and under what statute the way it was created. 1, generally any easement reserved for the public, whether a road, trail, utility easement, sewer line, recreational easement, etc. This is one of the places where the confusion comes in, because public easement is a term that's been used for a long time to mean all kinds of things. And then all of a sudden it was assigned to mean something rather specific, which doesn't include all the other things. So I think that needs to be one of the pieces of the definition. 2, an easement held by a municipality for purposes of public access to land or water not otherwise connected to a public way. And then, because of what I had discussed earlier in this, I added on no ATVs unless by permission of the abutting landowners. Snowmobile speed limited to, and we could decide what would be an appropriate speed limit within a certain distance of any residence. Generally, snowmobiles don't hurt these roads. They're riding on top of the snow. They're not riding on the dirt. They're not chewing anything up. So as long as they stay on the trail and don't go, speeding off through somebody's horse fence, which I've known to have happen, as long as they stay on the trails, snowmobiles don't really cause much of a problem. But the one thing that we do get complaints about is when the trail is too close to someone's house and the people wind it up and whine past them because all of a sudden they've got a nice wide open road to go down. So I think just putting a speed limit when they're close to a house might be a good solution for that. Number 3, a dead-end road laid out after July 29th, 1976 on the petition of an owner of land not yet connected to the public road system. These roads are established primarily for the benefit of the petitioner and allow the public to get to and from that owner's property. Maintenance is the responsibility of the petitioner. So if that sounds familiar, that's very much like what the private way was originally. And just changing the name doesn't mean that it should also change the definition. There should be a definition that still means what it did originally. Number 4, a former townway discontinued by vote of the governing body of the town after September 3rd, 1965, or a former county way within an organized township if such way was continued by vote of the governing body of the town after July 29th, 1976. That's what I was going to say about the other one. There's a gap between discontinuance of townways and discontinuance of countyways. The law on townways changed in 1965 to say that an easement was automatically retained when the road was discontinued. That was never changed in the county law. So until 1976, when all countyways and organized townships became townways, roads that were discontinued by the county, countyways that were discontinued by the county, did not retain an easement until after 1976. So we have to be a little careful about saying, oh, any road discontinued after 1965 automatically retained an easement, because if it was a county way, that just isn't true. And then there's the exception, of course, unless said vote in either case specified no easement would be retained. Such ways were retained for the purpose of preventing landlocking abutting properties, or for purposes of public access to land or water not otherwise connected to a public way. These often used to be throughways, although lack of maintenance may result in their no longer being passable for their entire length. Number 5, a road laid out as a private road, see definition number 1 of private way, which has been designated as a public easement in order to allow snow removal and or limited maintenance under 23 MRS section 3105A. And this is what we've seen in Wyndham particularly. It's also been used in a lot of other towns where a town had been maintaining private roads for years, or at least plowing them. And then the court said that you can't do that. You can't spend public funds for a private purpose. But they found that the way to get around that was to say that it was a public easement, which means that the private owners on the private road can no longer exclude the public. But these being kind of similar to the original private ways, most of them are dead ends. Some of them might be a loop off of the main road and back again, but they don't really go across town. So they're at least not subject to as much public use as the discontinued roads that went from one county to another. Let's see. Number 6, under 23 MRS section 3021, private ways are now also called public easements, with the exclusion of those under definition number 1 of private way. In other words, you can't call it a public easement if it's actually a private road that hasn't been designated as a public easement. And then 7, with the exception of definition 1 of public easement, 23 MRS section 3105 does allow a town to vote to provide some public maintenance of public easements subject to the provisions of that statute, if it is deemed in the best interest of the public for fire or police protection. However, it has no obligation to do so. I should say the town has no obligation to do so, and is not liable for defects in the road. Abutting landowners have the right but not the obligation to maintain the way so as to preserve access to their property, but receive no compensation for the public's use of the way. So that's as far as I got with it. I still figure this is kind of a work in progress. I'm sure there are going to be questions people have on it or things they disagree with. But hopefully if you get a chance to go back and read through the history that I put before it, you'll understand the reasons why I felt that those separate definitions were needed.
Right.
Any questions, comments? things you like, things you don't like.
Let's start with private way. See if we can organize our thoughts and comments. Roberta, thank you for putting that together as a starting place for us. Yeah, I would view it as a definitely a work in progress because there's so many concepts in there. But it's an attempt to try to put it all in one place. What will be interesting is whatever the result is, trying to work it into existing statutes. Because it'd have to be a repeal, replace, or amendment. Something would have to give, but we'll worry about that one last. The question is, what would you want in state law to define private way? Thoughts, reactions to what Roberta suggested?
It's like I tell my classes when I'm teaching. If you have no questions, either it means you understand everything completely, or it means you're so confused you don't know where to start. Should we take one piece of the definition at a time and see if people agree with it or not?
I think one way you could look at this is to say that the private way, for example, is one term, but it has several meanings. Rather than may have more than one meaning, and it depends on context. It is one word. It incorporates all of these different things. So you have to figure out which it is, I think, is your point when you're looking at it. I would disagree with one, get things started. And I'll tell you why. You use the subdivision as an example. When a planning board approves a subdivision, you've got this 2x3 foot Mylar. It has streets shown on it. They're paper streets until they're built and accepted, and lots are sold in reliance on the plan. And when those roads are built, until the town adopts them, I would prefer to call them private roads. I think to call them private ways is inviting more confusion rather than resolving any. And I always think of them as private roads because there is a public right of incipient dedication. That's the legal mumbo jumbo. The town has the ability to accept those and make them townways. In some subdivisions, particularly where you have like condominium projects, those roads are never going to be townways. They are always going to be retained by a homeowners association, which the developer may give the title to. You asked who owns the roads, and it's a darn good question. I'm fighting with that over a subdivision in Wyndham right now. And where the developer went belly up halfway through without starting a homeowners association. There was a foreclosure. Who owns the roads? Because typically what happens is if the roads are going to be retained by the homeowners association or given to the town, first the developer fixes the roads, builds them, then gives them to the homeowners association, who then may give it to the town if it's going to go to the town, or keep it itself. So in many instances, particularly the condo situation, the homeowners want to control their fate. They don't want the general public on those roads. They want to use them as their driveways, or for their guests, or for their invitees, or for the gas company, or for UPS, or for whoever they're doing business with. They want the general public off of the condominium roads. So those remain private roads. Not private, not in my mind private. In my mind, private way sounds like a private road, and that's the confusion. We all know on this conference that when we say private way, we were talking about a road where there's a public right of access. So we know that we need to, that's why maybe the legislature has stopped using this in new laws, except when they don't understand it. And that's why we have to get rid of that use of private way when we're talking about private roads in Title 23-3101. What we proposed a substitution for, a public easement for private way. I think we need to keep pushing that direction when we get there. But for right now, a road that isn't a public way, that isn't intended to be used by the public, I would prefer to use the term private road exclusively in referring to that road so that there's no confusion. Does that make sense?
Yeah, I agree with you completely. The only reason that I put that in there is because I know there are people who use the term private way to mean a private road. And maybe what that first definition needs to say is that that's an improper usage of the term. But I know we had somebody, I think it was Kathy Nadeau, who said, well, what does it mean when the sign at the end of the road says private way? And what it usually means is that it's a private road, not what we know as a private way. And somehow we need to let people know that, yeah, it's used that way, but that's not really correct.
I'll bet that I haven't been to Ace Hardware in a while, but I bet if I go down there'll be a stockpile of signs that say private way, and people who own private roads might be putting those signs up, and they're sending the wrong message. I don't know that we're going to be able to prevail on Ace Hardware, but that I think that may be part of the confusion we're seeing. What do you think?
Well, haven't you seen road signs that have the name of the road and at the end it's PVTWAY?
Oh yeah, that's what I'm suggesting. Yeah, there's some.
But those are
maybe
put
some.
up by the towns. Those are put up by the towns. They're official municipal signs. I'm not sure where they're ordering them from, but maybe they're made in another state that has different rules.
Well,
no, they're probably made from typical vendors in Maine, like White Sign up in Old Town. And the town probably just calls up or send them an email and says, hey, I need Scribner Way, and can you put private after it? And by the way, make it a different color too, because we use different colors for public versus private. I don't think people, the guy or gal ordering the signs has no idea there's a difference between a private way and a private road.
If it just
give me a private road sign, will you?
Yeah, if it just said private, that would be fine. But when it says private way, that's where the confusion comes in. And as for the colors of the signs, I remember my husband was on the E911 committee way back when they first started it. And he kept trying to tell them, you're supposed to have green signs with white lettering. If it's a town way, you're supposed to have, blue signs with white lettering, I think, was for private roads. White and red signs were for fire roads, and brown signs are for government roads. And he kept telling them, you've got to have these different colors of signs. That's what E911 is requiring. And the town said baloney and put up all green signs with white lettering, no matter what kind of road it was. We've been through other towns that have maroon signs. We've been through towns where all the signs are blue with white lettering. We've been through towns where all the signs are white with red lettering. It depends on how well their town read the requirements and how well they followed them. So there's a lot of confusion in it. Maybe the thing to do is tell them, if you have a sign that says private way and it's on a private road, go out with some spray paint and just paint over where it says way.
Well, actually, that's not quite right, Roberta, because there's no requirements. In fact, there is no requirement at all. There's nothing in state law that says any town has to put up any street name signs at all, even for 911. It is not a requirement. Is it best practice and a wise thing to do for public safety? Absolutely. So everybody does that. And all the sign colors are not driven by any requirement at all. It all comes from the MUTCD, which suggests that the main thing that the color be contrasting. And it suggests that green is typical used, but also red, black, and the other colors can be used as an option. So there's no requirements on this stuff at all. It's just typical practice.
Okay, I stand corrected then. It's not a requirement. It's maybe a recommendation.
Yep.
But it is kind of confusing when you go from one town to another and the sign colors mean different things.
Yep.
what it sounds like, Pete, is that when you're doing your training for municipalities through the local road center, it makes sense to be explaining to them the difference between public and private ways, private roads
Yeah.
versus private ways, and that you do not put up a public road type sign for a private way. If it's a private road, it is a private road, and don't call it a private way. That's probably something in the training. And are you still doing those training sessions with public officials?
Yeah, in fact, the new MUTCD just came out nationally, and I was hoping to do something this fall, but the feds haven't got all their stuff ready yet, so it's probably going to be put off a little bit. But yeah, that would be part of it.
Do you coordinate that with Maine Municipal Association's training programs?
Say that again?
Do you coordinate your training programs with Maine Municipal Association?
Yeah.
Do you have a staff attorney come by with you?
I have on occasion, but not that particular subject.
Of course, there's another opportunity at the MARA conference, not this weekend, but the following weekend.
Yep. Yeah, we can talk about that there too.
So I understand the issue on one, and I think the issue on one highlights the confusion that's out there in the public. And our job as a commission is to dispel that confusion, to try to break through that and get rid of that confusion. So I think we want to try to make sure that we don't include the concept of a private road within the concept of private way. Private way in Maine law has been used to mean something where, over time at least, and certainly now, there's a public right of passage. And it doesn't refer to private roads. So are we okay with that part?
Yeah, I still think there might need to be something pointing out that that's a misapplication and that's not what the term means. But maybe that shouldn't be part of the definition. Maybe it should go, I don't know, as a footnote on the definition or something of that sort.
Certainly, maybe in this is always a summary, a legislative summary that goes along with proposed legislation. So if we're proposing to change the definition of private way, we might add an explanation that despite common usage, a private road is not a private way, something like that.
Okay, I'm going to jot down that phrase, despite common usage. That sounds good.
That's what I got paid to do. But yeah, okay. So 2 is something that, a distinction that you've pointed out, that this is one of the classes of roads that gets included in when we, back in 1976, the legislature said all private ways, statutory private ways, are now deemed public easements. These are included. And as you've explained, these are the ones where you're taking improved properties and trying to connect them through these one-way roads, these dead-end roads from the farm, from the business to the nearest public way. So that's what I think you're trying to get at through 2, taking improved properties and connecting them to public ways. Where I would say, gee, I need to connect my farm. Here's the land. I've got rights over the land that the town will accept as private way. And then over time, the legislature explained, and you note in Brown v. Connor, the law court decision back in 1944, these are private ways. The public may use them. They're subject to gates and bars.
Yeah, that's another thing that changed is they took down the right to have gates and bars on them.
Let's talk about that for just a minute. I've never understood where the gates and bars go. Do they go on the road or do they go along the road so that people can't get onto my property?
They go across the road so that people have to stop and open the gate before they can go through.
And go any further. Yeah.
Yeah. in my dissertation there, was to limit the intrusion of unwanted nuisance traffic. And in some cases, somebody had a cattle pasture that was on both sides of the road. And rather than fencing all the way down both sides of the road and having to move the cattle from one to the other, they just put a gate at each end of the pasture. And the problem with that is that at one point the court came along and said, well, they're obligated to respect the gate, but they're not obligated to shut it after they go through. And so if that was a case where there were cattle, the person who went through the gate was not obligated to close the gate to keep the cattle from getting loose, which I found rather interesting. I don't think they were considering that when they made that decision. In most cases, though, it was just to keep out unwarranted nuisance traffic. And I can point you to where that is. Let's see. Someplace back in here. I guess I didn't quote the whole thing. I just said prior to 1941, private ways were considered primarily for the benefit of the owners of land served thereby and might or might not be subject to gates and bars to reduce unwarranted nuisance traffic. There is a case that I pulled that out of. I guess I didn't cite it here. Oh, wait a minute. Here we go. On page 2, about halfway down, or 2/3 of the way down, the purpose of the legislature in authorizing the town to determine whether a private way shall be subject to gates and bars was to provide a method by which the owners of the land affected could lessen the hazard of unwarranted or casual intrusion on their property due to it being open to easy access from the main highway. In spite of the erection of gates and bars, the public would still have the right to use the way in the same manner as the parties who are primarily interested in it.
Okay.
That was in 1941.
Okay, 41, not 44. All right. So we have that language. So the term would include a dead-end road laid out prior to July 29, 1976, and that's the date of the big rewrite of the state's highway laws. I think I would add to it that the public may access these, or the public has a right of access over these.
Well, it does say and allow the public to get to and from that owner's property. Because where else would they be going if it's a
Well,
dead
that's
end road
true.
to his property?
Well, over time, I'll bet side roads
It's a possibility.
put in, and so there may be other reasons to go through. So there's a general right of public access over these. Other thoughts on this one?
I'm noting down what you just said. One thought that I do have is I really like the concurring opinion of Justice Wathen in Brown versus Warchalowski. It's about a page long. Do you mind if I read that?
Go ahead.
He says, in explaining the evolution of the concept of a private way, He says, I concur in the result reached in the court's opinion, but find it necessary to state my views separately. The premise of this case, by the way, was that a town had laid out a private way for someone without determining if there was a public need for it. And it got taken to court. The lower court first said that, yes, the town had a right to lay out a private way, but then it got appealed. And on appeal, it was argued that they only had a right to lay it out if there was a public need for it. And if there was no public need, that would be unconstitutional because it would be taking private property for private use. And the Supreme Court said, yes, that was indeed unconstitutional. Anyway, in the concurring opinion, he says, I find it necessary to state my views separately. I would hold that 23 MRSA section 3006 is unconstitutional because it purports to authorize the laying out of a private way without a finding of common convenience and necessity. I would not attempt to reconcile the past pronouncements of this court or engage in any effort to further construe the statute. It should be recognized that we are dealing with a constitutional anachronism. The historical background and the evolutionary development of the law from colonial times to the present day has been cogently summarized as follows. A study of the history of those uses which originated with the first settlement of the country brings us back to a period when the natural obstacles to the successful establishment of permanent colonies in America had proved in many cases too formidable to be overcome. At a time when the very life of the community depended on the most advantageous use of every resource that could be availed of, it was not to be expected that over-refined scruples with respect to the rights of private property would be allowed to stand in the way, or that an individual who held his own title from a colonial grant would be allowed to use that self-same title to thwart the efforts of others to keep the colony alive. Furthermore, it is to be remembered that there were then no constitutional limitations upon the powers of the legislature, and that every colonial statute was necessarily valid unless it was repugnant to the charter of the colony or is forbidden by English law. It was under such conditions that private individuals were allowed in certain instances to encroach upon the property of others in order to develop the natural resources of the land for their own gain and for the incidental public advantage. In other words, say somebody had a good spot for a mill or something to that effect. Statutes which authorized such encroachment were looked upon as reasonable and wholesome laws, even after the conditions which made their enactment a public necessity had passed away. When the state constitutions were adopted, such laws were not in terms prohibited, and it was not at the time private property for public use was intended to prohibit them. It was many years before any doubt was thrown upon the constitutionality of such legislation, and it was then too late to disregard entirely the long acquiescence of the public in its enforcement. Sacrament Public Use Updated, City of Oakland versus Oakland Raiders. A review of the case law in Maine demonstrates an evolutionary response to an encroachment on the Constitution. The historic justification is no longer valid, and the Constitution no longer permits private advantage to override property rights to the extent contemplated by the statute. Neither public acquiescence nor antiquity supports continued toleration of Section 3006. I find the statute to be unconstitutional and therefore concur in reversing the judgment of the Oxford County Commissioners.
It's a good point. If you're going to lay out and take property, a local government or a state government, under Maine's Constitution, property can only be taken for public exigency, a necessity, and for public use. And so if there's going to be a public necessity, it can't be for one individual. And yet this statute authorized taking land on the basis of one person's need. I have a farm and I need to connect it. I'm going to give you the property and the town's going to acquire it and thereby get this right of public easement, a private way to get to and from my farm, and the public can use it. That's not the way that we do that now. And I think Brown v. Warchalowski probably wouldn't have been a case if no one had contested the ability of the municipality to take the property. If it had just been everybody shook hands and said, yeah, this is great, we'll now have a public, private easement to get a private way to get to your property, there wouldn't have been any issue, but somebody objected to the taking of the property. And so in order to make that law constitutional, you would have to read into it the requirements for taking it. It'd be for a public necessity and for a public use. Where there was no showing of public necessity, that's what the justices said, sorry, we can't condone this. We might have allowed this to happen years ago because the Republic was just starting out, and more importantly, nobody contested it and raised the issue. But once the issue was raised, it was clear that really the only authority to take a road is where you can make those two showings, and if you didn't, then it had to go back for a new hearing for a showing. And so there was a follow-up, Brown v. Warchalowski, and talking about the actual public necessity. So yeah, I agree that go ahead.
Yeah, there are a couple of things I find interesting here. One is that there's a series of cases that I have in another paper that I wrote up showing how the concept of a private way changed over the years. And you can really see jumps in it from, at first it was fine to take it for somebody's private use. And then next case saying, well, it's fine to take it for his private use as long as the public can use it if they need to. And it went up through, I think I already mentioned, there was a series of stages until it finally got to the point where, well, actually it's a public road. The other thing that I find interesting is that it's unconstitutional to take one person's private land for another. Okay, to take it for the general public's use. Excuse me?
You froze up there for a moment.
Just as you say, Jim? Oh, okay. It's okay to take one person's land for a public use. It's not okay to take one person's land for private use. But if you take it for public use, there has to be due process and just compensation for the taking. And that's where you run into problems with public easements that are maintained by a private individual, because you may not be taking his land as such, but he's putting his culverts, his gravel, his fuel for his farm machinery. He's having to buy farm machinery, maybe to grade the road or to rake the road or to dig rocks out of the road. And he's not getting paid for that. And the public is using it up. And as fast as he puts his work into the road or his materials into the road, the public uses it, and there's no due process. They just come in, they use it during mud season or whatever. There's no compensation. He got compensated once when they discontinued the road, but every time he rebuilds the road, he doesn't get recompensated for it. So where is the consideration of taking of that private property, his gravel and his culverts, etc., when it happens over and over again?
It's kind of confusing two concepts because the second one you said when there's a discontinuance, the first is when it's laid out. If I want to get my crops to market, I'm going to bear the cost of maintaining that road if it's the only way I can go. And I will pay the damages to other person's property that the layout of that road may take if it has to cross other people's properties. But you're right, it's over time, and it points out, for people who are strict constructionists and say, sorry, but you have to apply the state constitution and state laws the way they were written way back when. This evolved over time and evolved away from allowing that private access to requiring a right of public access over these private ways. And I think what the court was pointing out in 1941 in Brown v. Connors, we may not have recognized this all along, but it's supposed to be public right of travel subject to gates and bars. And it wasn't meant to exclude the public. The public has a right to use these private ways. I think that
one of the reasons our Constitution has lasted as long as it has is because it says right at the beginning that our rights were not given to us by men, they were given to us by the Creator. And that's why men can't change them. If our rights were just given to us by other men, then men could just change their minds. And if we find that there is something wrong with the Constitution, there is a procedure for amending it. But it's quite a process because it's not something that's done lightly. You have to really consider whether you're changing it for the convenience of men, or whether you're changing it because something really needs to be changed. And what we've done instead is ignored the Constitution and gone ahead and made laws that conflict with it. And that's a problem. If we need to the Constitution, we need to change the Constitution, not make laws that ignore the Constitution.
Well, I think maybe there's been an interpretation issue too, whereas originally the Constitution wasn't interpreted in a way that would block this concept of a public, a private way, because there was no public use. It now is. It's now interpreted to apply here. So I mean, over time, the application of the Constitution can change. And it did here in order to actually protect private rights more.
Yeah, there's also a case that says that if a law is found to conflict with the Constitution, that the antiquity of that law will not save it. If it's been unconstitutional for years, but you only just realized it, then just because it's been a law for years doesn't mean it's right.
And that's the thesis of and really the main part of Justice Wathen's concurrence in that case, Brown v. Warchalowski.
Mm-hmm.
Just because we've been doing this a long time doesn't mean we have to keep doing it, especially where it violates the Constitution.
Mm-hmm.
So are we okay with the concept in 2 that this is a class of private ways that is included within the term private way? With the exception maybe of adding to it that there's a right of public access. Going once, going twice? All right, 3. And 3 and 4 we can talk about together because it's really the same thing except for the time change. That basically a private way includes a former town way that was discontinued by the town's legislative body after September 365, but before July 29, 1976. I think that's fine. I think after July 2976, those are considered public easements by statute. What this means is this. Before 1965, September 65, a town would discontinue a road. And if the town discontinued the road, said, we don't need this anymore, we are terminating the public road rights. The town could, if it wanted to, add that there would be retained a public easement, a private way subject to gates and bars, typically was the language, but that there would be a private easement, the private way retained.
Can you show me where in the law it says they could do that?
Well, there's nowhere that says that they can do that, but that was the practice, as we've seen. And that was the practice at the county level too, that there would be retained a private way subject to gates and bars. And the practical benefit of that, as we've talked about, is that it at least gave people who owned property on those roads access that they might not otherwise have had, because there would have been no need for a private easement because they were on a town way.
I agree that it may have been a good idea, but I think they should have changed the law to say that they could do that. Again, if you go back and look at the history I wrote up there, there is a whole slew of cases saying that the county commissioners were very strictly bound to exactly what their powers were, and they were not allowed to do anything that was outside of their powers. And we haven't been able to find anything within their powers that said they could do that. I know in the case by the town against us, they said that, oh, well, they were allowed to take an alternative action. Well, an alternative action doesn't mean that you can do something alternative to what you're allowed to do, or that you can do something alternative to what the notice that went out to the public said you were going to do. An alternative action, the reason that was put into the law in the first place was that there was a case way back, was it Shepard's revision of the law, way back in the early days of the state. The first version of the law, a question came up because there was a town that that wasn't sure which, or two towns that weren't sure which side of the river would be best to put in a road. And so they went to the county and said, put in the road on whichever side, whichever of these two locations you find is best. And the county went ahead and chose one of those two alternatives, which had been in the notice. The public knew that that was what was being contemplated, was to put the road in one of those two locations. So there was proper notice and everything. Both proposals were before the county commissioners, and they decided on one of them, and the court said, yes, you can do that. And then when Shepherd revised the statutes, he added in that clause that said, or an alternative action. And that was pretty clearly to cover that situation of where there are alternatives presented, that they can act on those alternatives. It was not to say that they can do anything they please. If that were the case, then there would be no limitations on what they could do. You could ask them for a road and they could put in a canal instead. Or you could ask for an east-west road and they could put in a north-south road.
So are you asking us to disregard private ways that were reserved by act of the county commissioners or the, well, in this case, the towns before September of 65?
I'm not asking you to reverse all of that because it's a little late now, but it would be good to have it at least acknowledge that alternative action doesn't mean you can do anything you please. And that we suffered wrong because my husband was told that it was discontinued, it was private property, the town had nothing to do with it, and then they changed their mind.
Well, I can't solve your issue.
I know this commission isn't just for my issue, believe me. But,
I know, I understand.
I have to get that in there, or my husband won't forgive me.
I understand. But this definition really only covers those private ways that resulted by discontinuance between 65 and 76, when the legislature said there is a presumption that there is a private way reserved upon discontinuance unless otherwise specified by the order of discontinuance. So it only would encompass those. Shouldn't it also include those private ways that were reserved when the presumption went the other way, that there was no private way retained unless one was specifically reserved? Wasn't in the statute, but that happened.
I was just trying to break it down into all of the possible differences between the different ways of getting there. It does end up with the same result.
Well, we could say, let's say 4. We were at 3 with this one. We got rid of 1, but I don't want to scramble us all up. So 4 would be private ways reserved in municipal discontinuance before September 3, 1965. Does that make sense?
I'm not sure exactly how you'd mesh the wording of the two together. There probably is a way to do it.
That'll be something we can work on. And maybe what we could just say would be private ways reserved in discontinuance A, before 1965, and B, between 65 and 76.
Yeah, that could work.
Okay, and that way we keep the numbering system, so that works. And then 4 would be where there's a discontinuance. And just to explain, the county commissioners have had jurisdiction over roads leading from town to town. They could lay out, discontinue roads or parts of roads that went from town to town. And that was their authority until 1976. And then all those county roads became townways. The only roads that the counties now have jurisdiction over are in the unorganized territory. So we don't really deal with the UT very much, probably for good reason. Ryan would be on our case right now talking about that from the county perspective.
Yeah, there's some things that I think need to be fixed in that too at some point. When the abandonment statute was revised, it was revised sort of as if it only applies to towns, although it did say it applies to towns and counties, but it lays out the process for a town and doesn't lay out the process for a county.
Yeah, that said, if you go through county discontinuance records, I know I've seen it with Livermore when I had the Whalen case. There were instances where the counties would discontinue roads leading from town to town or portions of them, subject to gates and bars. So they did the same thing that municipalities did. They didn't have the statutory authorization to do it, but the practice was to do that in order to allow public access, or at least the owners to be able to access their own property where there was no private easement because it had been on a town way. So that 4 might be private ways reserved in county discontinuances before July 29, 76. So I think that definition, that certainly includes all the ways that you could get to private way. So it would be a private way would include all of these things. And whether you're dealing with a particular one would depend on the context.
You know, the one thing that I think is important to make a distinction on is the difference between the traffic on a road that was a through road and a road that has always been a dead end. Because that makes pretty significant difference in how much maintenance is required.
Well, I'll push back just a little bit on that one, because I agree that there's a difference, perhaps, if you're doing that just for one person or one, dead end road. But a lot of those roads may have started as dead ends. But if you started out, with a dead end road in 1840, I would bet that it's been incorporated into a road system over time and no longer is the same dead end road that was laid out back when.
Well, the problem comes when there's a road that was a through road that was getting public maintenance, and you stop the public maintenance, but it's still a through road. That's where the biggest problem is. I
agree. I'm just saying that may have become a through road over time. It may have been intersected in a couple of places, and so I don't know that you can really make that distinction.
Then if it has become a through road, then it comes in the category with through roads.
Pete, do you want another road category? Through roads?
No, I'm not saying another category. I'm saying that maybe it switches categories from being a dead end to being another of the through roads you've already got.
Well, maybe when we talk about, but that's a good, actually, that may be useful, Roberta. When we're talking about an option for someone to come to town meeting and say, I want an order directing a certain level of maintenance on my public easement, we might specify that for through roads, there is a different level, minimum level, than for dead end roads. That's a detail, I think, a gloss on that, which I'm supposed to be drafting and will. But maybe that's where that comes in when we're talking about what level of maintenance do you want as a base level for a public easement. And if we were talking about that option, because we know towns have the right but not the duty to maintain public easements. Maybe you say that for a through road, there's a different minimum level than for a dead end road. And I don't know the answer to this musical question. We'll work our way through it, but.
Yeah, I think kind of the opposite is true also. I'm not saying that what you're saying isn't true, but that there's another option, which is when there is a through road, one of the things we've suggested to decrease the amount of maintenance that's necessary is to divide it into two dead end roads, one from each end. You could have a gate in the middle, which the fire department has keys to in case they need fire access to, something in the middle, or that it's shorter to get into a piece of forest land from one end than from the other.
You put the moat with the alligators in the middle?
There's an idea. That might be a little harder for the fire engines to negotiate, though. But we've often argued on our road. They actually renamed the other end of it something different to distinguish between the two ends, because there've been so many problems with emergency vehicles coming in from one end when they need to be on the other end, and they come in 3/4 of a mile and find out they're 1/4 of a mile from where they need to be, and they can't get through, and they have to back up, go back out 3/4 of a mile, go 7 miles around, and come in from the other end. So that can be a problem too. But there's also the problem that when you have people that are just booney cruising and they see that it's a through road, they're often the ones that tear the road up the worst. And if word gets around that, no, that road actually doesn't go through anymore, it really is blocked in the middle, then that can decrease a lot of that. I've had a couple of requests recently from people saying, somebody wants to log on my road. Do they really get to use both ends, or can we restrict them? Can we put up a barrier at the end of our property and say they have to use the other end? Or once the logging operation has opened up the road, people are going to see that it's a through road. They're going to start using it. Can we put up a barrier after the logging operation is done and stop it from being a through road again? I also know of one case where a town said that when there were more than 4 houses on the road, that they would resume maintenance. And when the 5th house got built, they divided it into 2 roads so that neither end has as many houses as they said they had to maintain. So, this can work both ways. There are cases where a dead end road might become a through road, and there are cases where a through road maybe should become 2 dead end roads.
All right, we've had a fair discussion on this potential definition of private way. I haven't heard from everybody. We haven't heard. It's Joe, Carla, Rebecca, and I know Pete's commented, but do you have any thoughts on this?
I'm one of the confused bunch, so I'm just trying to catch up and sorry.
I'm joining Carla. I was confused with the whole discontinued roads from past experiences, personal experiences, and everything else. And I'm not sure I'm any clearer today than I was before being asked to be on this committee. But
okay.
It's been very educational, so a lot to think about, quite honestly.
I hope when you get a chance to read through it that will help undo some of the confusion.
Yeah,
Rebecca?
I think when I dissect it a little bit more, definitely will help. But there's a lot in there.
Rebecca, what did
Yeah,
you have?
I mean, it's some of the history. I mean, we can go into detail around, but is not really useful, I think, to the current perspective. But we could debate that ad nauseum. The through road piece, sometimes it's not created by the municipality at all, and sometimes it straddles municipalities. Sometimes it's created by the people on that road that actually links to municipal roads. And there is significant questions at the municipal level as to what they can and can't do around that. If it wasn't created by them and it's actually over someone else's property, maybe an absentee owner, there's not a lot a town can do in order to maintain that. So the same issues that exist with the county discontinuance impact the municipal ability to find a remedy for that.
As a definition, though, just as a starting place to understand what the various components are for a public easement, for a private way, does that help us at least to reach some agreement?
I think we had agreement in the previous version of the terms that mirrored what the court had interpreted and how they interpreted them historically. And I think that's important because if we don't maintain some sort of connection with those historic decisions, we're putting ourselves into yet another space where it's demarcated by time that is either confusing or unpicking, or again, makes it really hard to figure out how to deal with these roads that have segments in them that were discontinued at certain times by certain entities or never continued. And in the case of Wyndham, where no good deed goes unpunished, there, was a desire by that community to do something positive for those individuals. And what they needed was the easement over that, because you can't spend the public funds on the private roads. So that easement needed to be adopted rather than on an annual basis. They had forgotten that it had to be an annual basis. So that was a private and special law. It is not a statewide law. And I think that's also needs some sort of clarity. Private and special laws are very individual circumstances. They are not for all other communities to pursue. That was a remedy specific to allow those people to actually have the level of maintenance that they had without having to go back through and litigate constitutional matters about what the town did on their behalf to benefit them that they probably shouldn't have. But
part of what becomes confusing is with regard to we have a definition of public easement in state law. We don't really have a definition of private way. It said it means a public easement as defined by, but that's it. So we're coming up with a definition of private way to account for the history of it. I'm wondering whether that's useful, whether what's really more important is having a good definition of public easement that we can employ. And I think that's where we were heading last year when we were working with this, trying to replace that term private way with public easement. And right now with public easement, we have two definitions depending upon how it's created, as far as who can use it, which is, I think, problematic. But that
is that true in practice though? Because if it's a public easement, I don't think the use of that public easement is a public easement. I guess I don't understand what your point is. Like, when it's been interpreted as a public easement, then it is used as a public easement. Are you saying
if a public easement is created by discontinuance or statutory abandonment, it has one set of restrictions that doesn't apply if it's been discontinued previously, and that's got to be confusing. The whole bit about snowmobiles and motorized wheelchairs. I understand. I don't want to offend anybody. I realize there are reasons for it, the ATVs and all, but it's just depending on how you create the public easement, you can create different rights and different users, and that's the sticking point for me. You don't have one real definition of public easement anymore. You have two definitions, and then depending on how you create it, you have different users. And that's more of a challenge to me, because that's the term we're all using, private way. We run across it, but it really isn't used in a contemporary manner anymore. Maybe for the purposes of this committee, understanding it and what it includes, that's helpful. Maybe that will be helpful to the legislature in a historical sense of how we got here. But really, I think where the rubber meets the road would be with regard to public easement and its definition. And Margaret's on as a member of the public, seeing all this, but if you'd like to comment, I think we'd be interested in hearing what you have to say. Clearly, you're interested enough to be here. So if you'd like, you have to unmute yourself, that's all.
Oh,
There we go.
hello. Thank you for the permission to speak. And I appreciate people's comments of this is a very difficult stuff and I'm having a hard time understanding it. So welcome to our neighborhood. I fought with the legislation of the Judicial Committee when they created a private road section under 23 3121, I think it is. And the point being was because of we need two separate definitions. Private road, meaning gated, I can put a gate up, or it's private. This is not an entertainment. And the problem again, the word private way. Can anyone hear the word private? And why that's so confusing to the natural audience when you say private way? Well, that means public easement. And so this thereby is not really private. So it would really help the state of Maine residents and legislators and all municipalities, unorganized or organized, to have this clarity of definition. When I've presented to people a discussion on discontinued road, their reaction is, it's a dead road. It's a no man's land. And unfortunately, people misunderstand that there's a little catch that it has public easement connected to it. And thereby it's not allowed to be gated. Those are the challenges when we're describing these basic words to the lay community. I appreciate your points and about the first section, and particularly that issue of subdivision. Yikes, for planning committees and municipalities. Messy situations arise. I know Peter is involved with a member who deals with unorganized territory. It's called Road Ranger, who's responsible for dealing with some of those roads. And the prior road ranger had some challenges with property owners buying some land on these discontinued roads, creating public access issues. Was there was a lot of these problems. So just trying to keep it simple, but I was the one that spoke up and said, remove the word and put in the word or, so that the management between private owners and municipalities could work cooperatively together, which is, I have property in Windham, Maine, and thanks to that law, I know I have fire and other protections, but at the same time, we also have our responsibility maintaining the road during the summer, mud season, and so on. So That's my comment. The definitions are driving anyone nuts, because every time I speak up about private way, I have to add the word public easement, because that word public and private need to be one word, since it's a joint public and private situation. I hope
Just an
that,
observation, that may be why the legislature in 1976 decided to take all those private ways that had been created and call them public easements to try to get rid of that confusion. Unfortunately, in the road association statute, which deals largely with private roads, but also public easements, they used the term private way and kept it there. And that, I think, has led to a great amount of frustration. But thank you for your comments, Margaret. We appreciate it. And thanks. Roberta.
A couple of thoughts. One is that you say you don't run into the term private way much anymore. I run into it all the time, partly because of my participation in NARA, which everybody's going under the private ways statutes to take care of their private roads. So I run into it there. I also run into it constantly where people get in touch with me and they say, I've looked up the deeds. I'm trying to figure out what the status of this road is that I live on. And it says it's a private way. What is that? And so it's not going to go away no matter what we do. We can't erase it from all that old paperwork. It's there. And we need to recognize that it's there, and we need to tell people what that means, because it is confusing, and simply introducing a new term doesn't undo the confusion, because that term is still there. As for section 3121 that Margaret was referring to, I've had huge problems with that. To me, it's an absolute nightmare, because what it was intended to do was to reassure lenders that if they were issuing a mortgage on a home on a road that was not maintained by the public, they wanted to be reassured that there was some method by which that road was going to get maintained so that that property would remain accessible. They didn't want to give a loan for a house and then have the person not be able to get to and from the house. And unfortunately, it got worded badly, and it results in a lot of problems. One of them being that there's no due process for setting up a road association. It's something that just sort of happens. And so if somebody new moves in and says, I think I want this road fixed up, I'm going to bring in landowners. And all of a sudden they get a bill and they have no idea that anything was going to happen. So that needs to be fixed. But also, because it's not really clear what a private road is or what this law refers to, it's been applied to roads that it should never been applied to. Yeah, it's nice when somebody comes and says, I can't get a loan because I'm on a discontinued road and I need to be able to prove that this road will be maintained. Well, maybe you shouldn't be buying property on a discontinued road then, because it's not going to get maintained. What happens, or what I've seen happen 4 times already, and this law has only been in place for a couple of years, I already know 4 cases where a title insurance company has had to fight to get access because the buyer was told, oh yeah, there's shared access because this is a private road, so automatically the abutters share in the maintenance of the access. And it wasn't a private road. It was actually a discontinued road that was discontinued without easement, or at least that somebody was claiming that it was discontinued without easement, whether or not that's true. But the title insurance companies, in 2 cases that I know of, they've actually had to pay the person back the full purchase price of their land. In the other 2 cases, I think they're still pending in court or headed for court, trying to figure out what the status of the road is and whether anybody actually has access or not. So somehow that law has got to be straightened out. And that definition of private way is right in the middle of it.
It is, and it's unfortunate that private way is still used under that private road statute. That's something that we had asked to have changed, and maybe we'll have to ask again, and maybe present a better reasoning to state and local government for that. For today, I think we've come up with, I think, a general agreement on what a definition of public-private way is, whether we need to add that to the statute or whether it informs what we do as a commission, what the commission does. We'll see. I agree that there's going to be, I could pick up orders from the town or from the county that will say private way subject to gates and bars, and it would be nice for us to all understand what that means. Whether that takes a statutory amendment, I don't know, because it's something that case law defines. You just have to go searching for it. But we do understand what we're working from. I think we can all agree what the term private way includes. So I'll try to write that up. What I'd suggest is that we've used up a fair amount of brain power talking about that today. Maybe what we want to do is take a look at that and then come back and think about public easement and how that might be defined, because it will include private ways. It will include the leftovers from discontinuance and abandonment. We might want to think about what that really means, because we want to use that to replace the term perhaps private way in that road association statute. And then thirdly, we might want to come back and look at that 3121, because it seems to me that if there's the concern of who is there to take care of the road can be addressed by creating a road association under the road association law without having this 3121 out there causing mischief. There's already a way to address it.
And my thought when they first came up with it was, I hope that this will motivate people to form a road association so that it doesn't fall back on this, everybody shares equally, whether that's fair or not. But that isn't what's happened. What's happened is that people just assume that everybody's going to share equally and that they all know about it, which they don't. Most landowners have no idea this law exists until suddenly they get a bill from another landowner saying, here's the share that you owe. What do you mean I owe? I never had to do that before. Or, maybe one of them has been the one who's been doing all the maintenance, and all of a sudden he's being told he has to pitch in on something. So that's one thing that really needs to be fixed. The other thing you just mentioned, case law, having to dig through case law. One point that my husband keeps making is that, well, first of all, the Constitution says that only the legislature can make laws. So what's the court doing making laws? That's not in the Constitution. And
well, the court doesn't so much
that,
make law. The court can interpret what these terms mean and can interpret the Constitution. And so we have a whole body of case law out there, which the legislature never enacted. It's the judges, through case by case, depending on the facts presented to them, make the law over time. And so you really have to consider both the written statutes and case law.
But the problem with that is that if you want to look up the statutes, they're all on either online or on a shelf in the state law library in Augusta. You can go there and you can look at them, or you can pull them up online and read them. But the case law, as you call it, is not codified. So how do you find, you can't just, say where, do the statute search and say, where does this term come up? Because it's all over the place, and you can't get at Westlaw unless you're an attorney. So
well, you actually, I'll bet there's still, a lot of folks call them the red books. And if you go take a look at the West annotated statutes of Maine, and I'm sure there's still an old school copy sitting in the state law library. We don't even have them in my office anymore. We all rely on the computers, and you're right, we don't all have Westlaw. But you do at the state law library and the county law libraries have access to the red bound volumes of West. And when you go there and you open up the statute, there are annotations, there are notes about the various cases, and they'll tell you which issues are addressed. And then you can take that from there to go find the cases that you'll want to look at where the courts explored, what does this statute mean? How do we interpret this term under these circumstances, under these facts? So there is a way you can link those two. And so I'd suggest you can take a look at what we call the red books, the West's annotated state laws of Maine.
It's the MRSA.
These the MRSA, and these are the red bound volumes, and they'll have the notes. They're updated annually, so that the most recent cases are reached there. It will link you to state Supreme Judicial Court decisions. It will not link you to Superior Court, but it will link you to what. But that's the law of the state with the highest court.
That's where we see a lot of the confusion, is where there are lower court cases that conflict with each other. Where, there'll be one case that says that because a road was abandoned after 1976, that common law can't apply. And then there's another one that says that because the road wasn't used for 20 years after 1976, that common law abandonment can apply. And they're conflicting decisions at the lower court level all over the place. And there are things that were misinterpreted at the lower court level and never got appealed because the people ran out of money. In town of Lebanon, there was a road that was discontinued by the county back in the 1930s. And the case of Jones versus Potter went through slightly after the Fayette versus Mander case went through. In Fayette versus Mander, they said that because the county had used the term private way subject to gates and bars, that means it's now a public easement. And in Lebanon, the county said that it was discontinued subject to gates and bars. They didn't use the term private way at all. But the lower court looked at that. And the TVs and dirt bikes have made an absolute mess of it. Then there's another road in Leamington where they did the same road, and they now say that it's a public easement, but the terminology wasn't the same.
Well, yeah, it does, but the law is basically whatever the highest court of the state says. And so we look at the Supreme Judicial Court. So if in Lebanon or they'd gone up to the law court, maybe the law court would have decided that the omission of private way was dispositive, but having that subject to gates and bars, I can understand why the Superior Court would have filled in the blank saying, oh, they meant public easement, private way subject to gates and bars. Don't know. But anyway, that's where you look. I mean, the law is whatever the state Supreme Judicial Court says, unless it goes up to a higher authority at the U.S. Supreme Court, which doesn't happen very often because you don't get those sorts of decisions too often that require their intervention. So take a look.
Part of the problem with that is that not everybody can afford to go all the way through the Supreme Court. A lot of people can't even afford to go to Superior Court, or at least can't afford an attorney. And that's where we need law that is law, not that can be interpreted and changed and decided to be something else than what it was originally.
Well, that's what the courts are there for, to interpret what's been enacted and to apply it to a certain set of circumstances that's in front of them at that time. Well, I think we've gone about as far as we can today with this definition of private way. I'll work up a draft working from Roberta's copy and circulate that. Maybe we should have a group 3 meeting after the commission meeting. This gets us started. It gets us started looking at terms, and I think we'll be ready to take a look at public easement next time, having worked our way through the private way that now by statute has become the public easement. Does that make sense, everyone?
Are we going to use Roberta's draft next time as a starting point for a public easement?
I think why don't we do that? Why don't we take the same tack and work through that and see. Yeah, let's start there and work through, and then we can, if time permits, then we can go on to section 3121 where all of this seems to hit. and see what thoughts there are. And I saw Margaret shaking her head. So Margaret may have some comments for us. I understand. Maybe Margaret will have some comments for us when we come to 3121, and we can get those. We can consider those as well. All right, that would be helpful to us. So thank you all for your time this afternoon.
And I apologize, I don't mean to monopolize these meetings, but you know, I've been at this for a while. I have a lot of thoughts on it, and if nobody else speaks up, I'm going to fill in the blank space.
Oh, I think that it sets us where we need to look, and so thank you, Roberta. I appreciate your work and teeing this up for this afternoon's meeting. Heather, thank you for coming up with Plan B and getting us on Teams so that we could have this meeting today. The state ran out of license authority for us to use Zoom, and so we're on an alternative bandwidth. And Joe, I understand the confusion, so if you want to give me a call sometime, maybe we can set something up on by email. We can talk about road discontinuance and abandonment, and I can try to confuse you even more.
Well, I'm with what Margaret said earlier, honestly, just seeing the different designated roads, discontinued roads, abandoned roads, public way, private, you know, all those different things. And I think I agree with what Margaret said too, as well. And Roberta and everybody's input is that got to specify exactly. Private means private and public means public. And so that's, I think, where I'm guessing we all need to kind of get to. But I'd be more than happy, James, at some point to have a conversation.
Give me a call. We'll make sure you become a Rhodes Scholar. All right.
Well, Rome wasn't built in a day, and you know, the changes don't happen overnight, and the expectations out there and the understanding of it all doesn't happen overnight. But change takes time.
It does. It does. And so we're going to try to make some incremental positive differences here.
Yeah.
So thank you all for your time this afternoon, and see you at the commission meeting next week. Thank you, Heather. Thanks, everyone.
And if I don't show up next week, somebody give me a call, because it'll be right after Common Ground Fair and I'll probably be half asleep.
Will do, Roberta.
Thank you.